So welcome everyone to the ICDR Y&I virtual Swiss Chalet event, Swiss Chalet debate, sorry. And as you can see, we've tried to craft our virtual background for the occasion, even though, of course, we cannot meet in person, at least we recreate a little bit. And I'm Rafael Carmona. I'm from the ICDR. I work on our young practitioners group, the ICDR Young and International, or Y&I, and I welcome you all. And I want to take just one moment of your time to, first of all, thank the organizers, Anya and Ben, and all the panelists. I want to thank you all for attending today. I want to also remind you that you can join ICDR Y&I. If you Google us, ICDR Young and International, you'll find our website where there are some forms that you can complete to become a Y&I associate. And you'll be also able to find our previous webinars there that we've recorded and uploaded. And also you can go to our LinkedIn page. If you look for ICDR Y&I, you will be able to find us, and we will post our updates there too. And I am looking forward to this debate, especially because you might be aware of it, but recently at the beginning of March, we implemented a new set of rules for the ICDR. And among the recent changes is an Article 23 on early dispositions that we're going to discuss today. And even though it was not amended, we still have Article 24 of our rules on the exchange of information, including document production, that is regulated rather extensively. So I look forward to seeing what our debaters have to say about these topics. And with that, Ben and Anya, I give the floor to you. Thank you.
Thank you, Rafa, for those introductory remarks. And welcome, everyone. My name is Anya Mrinkovic, and I'm a senior associate at Barr in Geneva, and also a member of the ICDR Y&I Global Advisory Board. I'm co-hosting this event tonight with my fellow board member, Benjamin Moss, who's a senior associate at Sidley Austin. On behalf of Ben and myself, I want to thank you all for joining us today. Last winter, Ben and I were discussing the possibility of reviving the Swiss Chalet debate series that was held in former years here in Geneva. And unfortunately, our plan was put on hold due to the situation we've all been living through this past year. And so I have to say, I'm really happy that we are finally now going ahead with it, at least virtually. And I hope that our next installation of the Swiss Chalet debate series will be able to be held in person. So now I'd like to briefly present our debaters before handing over to Ben. We have two teams this evening. Team It's All Hearsay is made up of Nina Lober-Thompson and Michalis de Castros. Nina is a Norwegian lawyer and counsel at the law firm of Levy Kaufman Koller, where she specializes in international commercial and sports arbitration. Michalis is a Greek lawyer who is a senior associate with the Geneva office of Sidley Austin and specializes also in international commercial and also investment arbitration. Our second team, who I've dubbed the dynamic duo, is made up of Laura Azaria and Stefan Den Hartog. Laura is a Spanish lawyer and a senior associate at La Live. She has extensive experience in international commercial litigation and arbitration, and as well as international transactions. And last but certainly not least, Stefan is a Dutch lawyer and recent co-founder of the boutique arbitration law firm Aza Avocat, who specialize in international arbitration and economic sanctions. So thank you all for partaking in this debate tonight. Now I hand the floor over to Ben to give a few more details on the topics and how it will be carried out.
All right, thank you, Anya, and Rafa also. Welcome, everyone. It appears as though we've got a great audience today. I've even decided to wear a tie, which is a rare occurrence these days, and not really in keeping with the Swiss Chalet theme. We have two great quickfire debates for you. The first debate will address whether the growing recognition of summary dispositions is a significant step forward for arbitral procedure. They're now reflected in the 2021 ICDR Rules at Article 23, and many other institutions recognize them. ICSID, LCIA, SEAC, HKIAC, SEC, ICC. It's a real alphabet soup. But is this procedural tool really needed? Can it cause due process problems? There's very little guidance out there, so hopefully you'll find the debate insightful. Stefan from Team Dynamic Duo will argue in favor of the proposition, while Nina from Team It's All Hearsay will argue against. The second debate is about document production. Should commercial arbitration further restrict it? We've all been there, tribunals and parties just gravitating toward the IDA rules, but should that really be the norm? What about the Prague Rules? Are they an affront to arbitration as we know it? Mihalis from Team It's All Hearsay will argue in favor of the proposition, while Laura from Team Dynamic Duo will argue against. And an important disclaimer, Anya and I have asked our debaters to adopt strong positions for or against. So these positions don't reflect our debaters' own personal opinions. That needed to be mentioned. Now, let me just give you a quick rundown of the structure of the debates. Each team will be granted 5 minutes for an opening statement. After that, our moderator will ask some targeted questions and request quick 1 minute or so responses. Before and after each debate, we'll have quick electronic polls to see whether audience opinions on the issues shift. And at the end, if time permits, we'll also give you, the audience, an opportunity to ask questions. And Rafa, correct me if I'm wrong, I think the ICDR will offer the winning debate team a luxury Swiss chalet in Verbier, which is very generous, great support from the ICDR. Thank you very much. And the losing team will have to make do with the consolation prize, a set of Alphorns. So back to you, Anya.
Thank you, Ben. So now I have the pleasure of introducing our esteemed moderator, Tomás Navarro Blakemore, who is a Swiss-Spanish lawyer and senior associate at FORIP in Geneva. He also specializes in international commercial arbitration. And without further ado, I hand it over to you, Tomás. Thank you.
Thank you very much, Anya, for this presentation. Of course, thank you to you and Ben and Rafael for making this happen. I remember assisting and attending the first Swiss chalet that I ever did, that I ever attended during the mids, and it was a fun debate. It was a fun event, and that's why I found this style of events really engaging, and the fact that we have these two teams and these topics that are really up to date guarantees it's going to be a fun evening. At least we'll see if opinions shift or not. So as explained by Ben, we have two teams with two debates and two topics. Of course, the debates will be have been pushed to the limit, and that's why it's always good to see if we reach these boundaries. And first of all, as also mentioned Ben, we will start with a poll just to see whether these opinions change at the end of the debate. So regarding the first debate, which is in relation to the summary dispositions, the question that our debaters have been asked to answer or to debate in favor or against is the growing recognition of tribunals' power to make summary dispositions a significant step forward for arbitral procedure? So now I'll leave it to Rafael to share the poll. So you can just answer yes or no. Once we have most of people voted, we'll keep an eye on that. I think we're nearing nearly most of us. Let's see how this works. Let's wait for another minute or so. Yes, and as Rafael mentioned, your vote is anonymous, so don't be shy. I think we're nearly done. Rafael, we can share now what's been voted. Okay, so now we can see definitely there is a majority in favor that it is a helpful development. So perhaps, well, Team B has a task for us to convince us of the opposite. And without further ado, I'll leave it to Stefan with his opening statement in favor of this question. Stefan, it's all up to you now.
Thank you very much, Thomas. Hearing from Rafael what the prize is today, I fully agree with you. We're going to push it to the limit. So let's see where we end up. Once upon a time, international arbitration was hailed as a fast and cost-efficient alternative to traditional court litigation. The harsh reality today, however, is that arbitration often fails to deliver on that promise. Disputes are too often administered without any differentiation. Claims that are manifestly devoid of merit are often subject to the same procedural timetable as other claims. A ruling on frivolous claims may take years to be issued following obscenely costly proceedings. Provisions in institutional rules on summary disposition offer a welcome and necessary solution to this problem. Summary disposition is the early determination on an expedited basis of an issue relating to jurisdiction, admissibility, or merits without a complete exploration of the evidence. There may be a limited exchange of written submissions and a brief hearing for oral arguments, but no document production, no evidence from fact or expert witnesses, and no full evidentiary hearing. Domestic courts in various jurisdictions already routinely adopt some form of summary disposition procedure. Until recently, in the absence of specific provisions in institutional arbitration rules, a party that wanted to make a case for summary disposition had the difficult task of relying on the tribunal's broad case management powers. But today, in an endeavor that is not only noble, but also vital to restore arbitration's reputation as a speedy and cost-efficient means of dispute resolution, an increasing number of leading institutions have, at last, made room for express rules on summary disposition. Leading the pack in 2016 was the Singapore International Arbitration Center, adopting a dedicated rule on the basis of which a party may apply for the early dismissal of a claim or defense. Other major institutions that have adopted specific provisions on summary dispositions include, to name just a few, the Stockholm Chamber of Commerce in 2017, the LCIA in 2020, and most recently, of course, the ICDR with the 2021 revision of its international arbitration rules. And even if the ICC arbitration rules do not explicitly address summary dispositions, the ICC's practice note specifies already since 2017 that applications may be made for the expeditious determination of one or more claims or defenses on the ground that they are manifestly devoid of merit or fall manifestly outside the tribunal's jurisdiction. So why did these institutions consider it necessary to include specific provisions on summary disposition? Precisely because summary disposition favors procedural economy by ensuring that justice is served in an expeditious manner. By enabling tribunals to promptly dispose of frivolous claims, and under some rules even of frivolous defenses, arbitration proceedings can be significantly shortened and the parties' costs and legal fees reduced. Importantly, even if only certain claims are dismissed at an early stage by way of summary disposition, this still allows both the tribunal and the parties to narrow down the issues in dispute and focus only on those claims with actual merit. This might even lead parties to consider settlement options at a much earlier stage of the proceedings. Yet another major benefit of summary disposition is that it requires arbitrators to dive into the substantive analysis of a case early on in the proceedings, mitigating the often heard criticism that arbitrators tend to familiarize themselves with the facts and legal issues only at a later stage. It is also not unreasonable to believe that the mere availability of summary disposition reduces the volume of frivolous claims filed by parties. Finally, summary disposition is a necessary innovation to increase the use of international arbitration in specific sectors, in particular the banking and finance industry, which historically still very much rely on dispositive motions that are available before domestic courts in New York or in London in order to quickly enforce contracts. To conclude, summary disposition is a powerful tool that has the potential to significantly reduce both the costs and length of arbitration proceedings. And it is therefore not just legitimate, but also highly desirable that major arbitral institutions update their rules and make summary disposition explicitly available to parties. Rest assured, the early determination of an issue does not raise any due process concerns. If anything, the existence of rules on summary disposition is a testament to the inherent flexibility of arbitration. Of course, arbitrators must ensure that they allow only those motions for summary disposition that hold reasonable promise in terms of streamlining the arbitration, and that the party's right to be heard is respected. The arbitrator's role in this process is crucial, but just as it is in any set of proceedings, summary or not. If arbitration is to deliver on its promise of offering a fast and cost-efficient dispute resolution mechanism, and more importantly, if arbitration is to remain a viable alternative to domestic commercial courts, arbitrators should not shy away from taking advantage of the possibility to address, perhaps dismiss, early on those claims or defenses that are manifestly insufficient. Thank you.
Thank you very much, Stefan. I think we'll dive in directly with Nina's position. Nina, the floor is yours.
Thank you, Thomas. Team It's All Hearsay would like to go back to the definition of the topic. That is the distinction between, on one hand, bifurcation, and on the other hand, summary disposition. Also, the distinction between summary disposition and documents-only proceedings. Are these concepts the same? Is summary disposition actually just another term to describe bifurcation of issues to be decided first on the basis of documents only? In our opinion, a new concept should really bring something new and not just introduce yet another procedural tool to be exploited by parties that seek to delay, frustrate, or derail proceedings, or even divert the attention from issues of substance where their cases might be weak. Obviously, in the right circumstances, it is very helpful and efficient to dispose of certain issues in a preliminary phase. But we put to you that this is already being done successfully within the existing procedural framework and powers relating to bifurcation. To be absolutely clear, Team It's All Hearsay do not dispute that bifurcating issues in the right circumstances might be a good idea. We simply suggest that there is no need to invent another procedural concept that opens the door for more procedural complications. If we take the relevant provision in the new ICDR Rules, Article 23, there are 3 procedural steps to complete in relation to early determination. The first step would be to address a request for leave to submit an application to have an early determination phase. If such leave is granted, the second step is to address the application. If the application is successful, the third step would be the early determination phase itself, typically 1 or 2 rounds of written briefs that may not be so brief. To us, it is evident that this represents a potential for significant delay. And we believe that it would be much more efficient to discuss once and for all and decide once and for all on bifurcation at the very beginning of the proceedings during the first case management conference, instead of keeping the playing field open for disruptive motions throughout the proceedings. Along the same lines, we know that the original working group who drafted the IBA rules on the taking of evidence hesitated back in the day to encourage what they call litigation style motion practice. Hence, the IBI rules only mention early determination in order to make clear that the tribunals have the power to bifurcate certain issues. Indeed, most arbitration rules, including the former ICDR rules, already provided for and presuppose that tribunals have this power to bifurcate and to issue partial awards. This brings us back to the original point. What does the new and specific regulation of summary dispositions or early determination really bring? Our colleague on the other side underscored that arbitrations are too often administered without differentiation, and that there is a need to be more speedy and cost efficient. Aren't these concerns already addressed through bifurcation? In addition, quote unquote, summary dispositions may be risky in terms of validity and enforcement. A summary decision or a summary award may be set aside or denied enforcement on the basis that a party's right to be heard in full was not respected. If your answer to this concern is that the decision should always be recorded in a proper award, then we circle back to the original point. How is summary disposition then different from bifurcation? Now, if we put the definitions aside and agree that specific regulation of summary dispositions in rules will encourage a more frequent use of bifurcation, we remain concerned that a too frequent use may be counterproductive and over time create bad habits. After all, we all know and we all see that costly and time-consuming document production phases have become the rule in arbitration, even in cases where there are only counsel from civil jurisdictions. We are also concerned that parties and tribunals too often will find themselves in situations where subsequent procedural steps, be it briefs or hearings, reveal that the early disposition was perhaps too hasty and that certain issues need to be reopened. Now, in view of all this, and instead of concluding, we would like to ask the following question. Has the appetite for innovation and the desire for institutions to demonstrate a proactive approach to efficiency gone too far? And have these two concerns jeopardized effectiveness by creating yet another arena for dilatory tactics? We submit that the answer is yes. Thank you.
Thank you, team. It's all hearsay. I see we've got 2 strong statements here, and there's definitely ground for Stefan and both for Nina to rebut each other's positions. But I'm going to take the lead on that, and especially in view of Nina's statement, and which has been obviously addressing Stefan's first concern when he was talking about delays and issues of efficiency and the fact that there's this growing concern that arbitration is costly and long. What do you say to this, Stefan? Nina mentions indeed that, for example, the ICDR rules provides different steps in terms of first granting leave for the summary disposition and then issuing a decision. Isn't that in a way in contradiction with the will to have efficient and fast arbitrations? What can you say to that to us?
Thank you very much, Thomas. Very good question. I think the answer to my answer to that question is no, and I think the argument that this is just adds another step to the process and in the end only delays the proceedings, at the very least is exaggerated, and I think it's not supported by the facts. I think the experience to date suggests that summary dispositions have a positive impact on the duration of proceedings. I think Rule 41, paragraph 5 of the ICDR Arbitration Rules, which was introduced way back in 2006, perhaps serves as the best, and I think only quantifiable examination on the use of summary disposition in international arbitration. And the numbers show that fears that it is either used as a tool for harassment and delay, or that it prolongs the proceedings are simply unsupported. First, objections under Rule 41.5 are relatively rare. Since the introduction in 2006, I think the percentage of cases in which a party has invoked the summary disposition procedure floats around 5 to 6% of the number of total arbitrations that is annually registered with ICSID. But what is perhaps even more important and encouraging is that ICSID arbitrations in which a party has invoked summary disposition, regardless of whether that was ultimately successful or not, are resolved substantially faster than the average ICSID arbitration. On average, the duration of arbitrations in which a party has invoked Rule 41.5 is over a year shorter than normal ICSID arbitrations. For me, the main takeaway from those numbers should be that summary dispositions really do streamline the arbitral process. For instance, by helping parties and arbitrators to narrow the issues in dispute and requiring the tribunal to focus on the substance of the dispute early on in the proceedings.
Thank you, Stefan. That was strong, and I guess you're supported by some facts. And I think this is a very important question in terms of delay or the so-called guerrilla tactics that also Nina evoked. And on that question, and also what you mentioned, Nina, at the end, is whether this is not a tool that institutions have been pushed to do to show their proactivity in ensuring that the process is more streamlined, more efficient, more cost efficient. But in a sense, aren't the institution pushed to have such a proactive, and aren't they in a way pushed by the parties, pushed by the users to provide at least these tools that then the parties are free to choose? These are tools, at least for the parties in an arbitration procedure, that can know, okay, we know our rights within the ICDR rules, within the LCI rules or the SEC rules. There is a specific provision that enabled us to do that. We use it or we don't use it. How do you see that going?
You asking me?
Yes, sorry,
Yes.
yes.
Oh, obviously we have all followed all of these Queen Mary surveys throughout the years, and you know the misconception, if I may, that arbitrations have become litigious, more and more similar to court proceedings and costly and too long. Of course, the concern is there, and I fully agree that bifurcating issues and having tribunals that are proactive from the get-go in the case, already start looking at the substantive issues early on and then decide to bifurcate. Of course, this is good case management. What I'm concerned with is to introduce another tool that may not be necessary, given that this power to bifurcate already lies in the inherent powers of the tribunal to manage the case. I am concerned that this can be misused, and I'm also concerned that the way I read many of these new rules that have been taken in by several institutions, I don't see any cutoff date in terms of how late in the proceedings you can suddenly put in a motion that, no, you know what? Now we suggest that we apply for the tribunal to stop the calendar, reshift the procedural timetable, and decide on this issue early on. If that is made, if such an application is made at the wrong time in the proceedings, you may end up with several years of delay. hearings and exchanges of document production phases and exchanges of witness statements, etc., would have to be delayed because of that. So to sum up, to be clear, our objection is not the concept of proactively cutting up the proceedings in phases, but to put into the rules this carte blanche to submit these motions at any point in time up until the hearing, for instance.
Thank you, Nina. I think that makes it clear. I'm looking at the time, and I obviously have plenty of more questions, but in view of the time, in view of the fact that we have another debate, and perhaps there's also the opportunity afterwards to ask some questions in the breakout rooms or in the Q&A sessions if we have some time, I think we should go ahead, check the poll, and see what are the results, if the power of persuasion of our debaters have shifted or not on our different opinions. So Rafael, if you can go ahead. I see the results are getting tighter. We'll share them. Not everybody has answered yet. Let's get to around 80%. I see Nina is trying to make some moves to see if that shifts also your opinion. I think, Rafael, yes, we reached a fair, well, around 80% of the people who have attended. I think we can share now the results. Well, we still have a winner, but the result is closer. So there's been some persuasion from our debaters. So well done to both Nina and Stefan for both of their position. And let's move on now to the next topic, which is the topic regarding document production. And the question that was posed to both our debaters, Laura and Michalis, was, should commercial arbitration further restrict document production opportunities? So this is obviously the question that we all face in most of our arbitrations. I'm actually in a document production phase right now, so I'm hoping to fish some ideas from our debaters, see if that will help in my case. So Rafael, can you share the poll again, and let's see what is the position of our audience at the beginning of the debate. Okay. So I see it's quite tight. Let's wait just another few seconds. I think most of us have answered by now. Rafael, I suggest you share now the poll with the audience. So it is tight. So we have 59% and 41% out of people who voted. But obviously, we'll see if that changes at the end. Without further ado, I want to leave the floor to Michalis, who is positioning in favor of this question. Michalis, the floor is yours.
Thanks very much, Tomas. As you said, team, it's all hearsay. Would like to argue in favor of a restrictive approach to document production, and also in favor of the application of the Prague Rules with respect to document production. So as we all know, document production in international arbitration is predominantly regulated by the IBA rules. Indeed, and since their inception in 1999, the IBA rules have been instrumental in shaping international arbitration, where parties from different legal cultures are involved. Despite their wide acceptance, however, the IBA rules have hardly taken an approach that promotes legal diversity or efficiency. Instead, they're largely based on the common law adversarial system. Indeed, the IBA rules are alien to the majority of legal systems in the world that are in fact civil law countries. They permit extensive disclosure and prolonged cross-examination of witnesses, which adds to the length and the cost of the proceedings, and confer an advantage to common law lawyers largely based in the US or largely working for US and UK law firms. In response to this creeping Americanization of international arbitration, in 2018, a working group of arbitration practitioners from more than 30 countries decided to suggest an alternative: the rules on the efficient conduct of proceedings on international arbitration, or in short, the Prague Rules. This working group drew on civil law practices to increase the efficiency of arbitral proceedings by encouraging tribunals to take a more active role in managing the proceedings. In short, the Prague Rules seek to encourage arbitral tribunals to adopt an inquisitorial, i.e. a fact-finding approach to the taking and assessment of evidence, including documents. Notably, and for the purposes of this debate, the Prague Rules adopt a different approach from the IBA rules with respect to document production. The rules adopt a narrow approach, with the tribunal and the parties being encouraged to avoid any form of document production, including e-discovery. A party's ability to request documents is maintained, but the requesting party must address its request directly to the tribunal. A party may request the tribunal to order the production of only a specific document, which is relevant and material to the outcome of the case, and not classes of documents or groups of documents. The tribunal may request documents on its own initiative, and any documents submitted in the arbitration and not otherwise in the public domain shall be kept confidential and may only be used in connection with the arbitration. We argue that the Prague Rules are a welcome development, and arbitration practitioners should promote their wide adoption, especially with respect to document production, for a number of reasons. First, the features of the IBA rules are often unknown to the civil law systems, and therefore promote its dominance and that of US and UK-based law firms in international arbitration. This deters many potential users of international arbitration. Second, and whether people like it or not, the reality is that most of the geographic world is made up of countries with civil law-based legal systems. As a result, a significant number of disputes arise between companies that are from civil law countries. There is no need to apply an expansive approach with respect to document production in respect of disputes between companies from civil law countries. In fact, most practitioners would anecdotally agree that document production under the IBA rules rarely hit the evidentiary happy medium. Parties are typically either overwhelmed by the number of document requests made by the other side, or overwhelmed by the sheer number of the documents produced. Document production can also be costly and very time-consuming, particularly for instance, in construction disputes or in investment arbitrations, in oil and gas contract disputes, where document requests can include copious drawings, notices of defects, contract documents, negotiating history. These restrictions may actually contribute to efficiency. Further, the arbitrators are perfectly competent to inquire into the facts just with the assistance of the parties and not being guided by the parties. Most arbitrators are experienced enough to be able to discern which documents are material to the determination of a dispute and to order document production by the parties. Finally, some opponents of the Prague Rules say that the inquisitorial approach is not consistent with the basic principle of party autonomy underpinning international arbitrations, and that if the parties want the tribunal to set the procedure like a judge, they should go to a state court. But this actually perverts the meaning of party autonomy. If the parties want to have a dummy as an arbitrator, they should be able to have one. But if they want a judge with control of the process, they should also be able to have one. To conclude, party autonomy and diversity are central tenets of international arbitration. Diversity should not only be restricted to gender, race, or sexual orientation, Diversity of legal cultures is also important. The Prague Rules promote this diversity along with efficiency and reduce costs while respecting the principle of party autonomy with respect to document production. As such, the civil law arbitration community should warmly embrace them and adopt them, at least with respect to document production. Thanks very much.
Thank you, Michalis. I think we've got, again, a strong statement on your behalf regarding the question. And it's now, I'll leave it the floor to Laura to argue against and saying that no, commercial arbitration should not further restrict document production. Laura, it's all up to you now.
Thank you, Thomas. As stated by my colleague on the other side, under the Prague Rules, parties are encouraged to avoid any form of document production. The least we can say is that the Prague Rules have come out of frustration. The frustration of a group of civil law arbitration practitioners against the so-called Americanization of international arbitration. Unfortunately, my esteemed colleague from team It's All Hearsay seems to be affected by the same syndrome. However, psychologists all agree that frustrations lead to irrational decision-making, and this is precisely what happened with the Prague Rules. The defenders of the Prague Rules, or more generally of a restrictive approach to document production, considered that the Americanization of international arbitration, and more particularly the features of the ICDR Rules on the taking of evidence, are one of the major causes for increased time and costs of international arbitration. The drafters of the Prague Rules solution is to limit to the absolute minimum the scope of document production. Indeed, the Prague Rules, as stated by Michael, exclude production of whole categories of documents, including narrow and specific ones. Only specific documents which are relevant and material to the outcome of the case may become subject to document production. With all due respect, the drafters of the Prague Rules and my esteemed colleague from team It's All Hearsay only see the dark side of document production. I'll give you two main reasons why a restrictive approach to document production must not be taken. But before, it's essential to clarify a point. Document production, when properly used, is not the cause of inefficiency in arbitration. Document production is not a waste of time or money. A document production procedure can be short and efficient at the same time. What is required is not another standard such as the Prague Rules, but a robust arbitral tribunal who properly uses its wide discretion to manage the proceedings. Then let me remind you that the ultimate goal of arbitration proceedings is not to be cheap and quick, but to deliver justice. And to achieve this goal, the relevant facts and documents must be submitted to the tribunal, if need be, as a result of the document production process. What the defenders of a restrictive approach to document production seem to forget is that the party's right to production of documents is a component of the right to evidence. Its very purpose is to enable a party to establish the facts on which it relies or to contest the facts submitted by the other party. Document production is therefore an essential element of justice. Consequently, a restrictive approach to document production, such as that set out in the Prague Rules, might result in cheaper and quicker award. But at what cost? The legitimacy of the arbitration proceedings would be called into question. The second essential reason against the restrictive approach set out in the Prague Rules is that these provisions are not suited to arbitration disputes. The Prague Rules abolished document production with the exception of requests for the production of specific documents. Yet in practice, in most cases, it will be impossible for a party requesting documents that it does not possess to identify them beyond indicating the category to which it belongs. This is particularly the case in arbitration cases involving complex factual reports, but not only. To conclude, a very restrictive approach to document production is not suited to arbitration proceedings, whether seated in a civil or common law jurisdiction. There is absolutely no reason to distinguish the rules of evidence in international arbitration based on the seat of arbitration, or to apply to arbitration proceedings a procedural concept prevailing in one or another jurisdiction. International arbitration belongs neither to civil nor common law systems, but constitutes a transnational procedure. As you all know, and as my colleague from Team It's All Hearsay agreed, the ICDR rules on taking of evidence is the most successful and generally accepted set of best practice standards. I'll conclude this opening statement with the famous adage, don't change a winning team. Thank you for your attention.
Thank you very much, Laura. I think there is obviously some room to discuss here. I will obviously jump on your last comments that you mentioned between if there is really this divide between the civil and common law systems in international arbitration. And that's something obviously I'm going to address to Michalis. If this is really the case, aren't we seeing now a whole pool of arbitration practitioners, exclusively arbitration practitioners, who, let's say, dive into this world directly from sometimes law school or LLM and are specialized lawyers in this field without these preconceived, let's say, practices, either on the common law side or the civil law side. How do you say to that, and whether the Prague Rules are really the result of a frustration, as Laura mentioned before? Michalis, the floor is yours.
Thanks very much, Tomas. Well, I think, I mean, she was right in the sense that these are those that we have been using.
Thank you.
You know, we've had no other option up until now. And in some ways, document production was a bit of a terra incognita for a number of years. You know, the reference schedule was devised by practitioners in an effort to make the process smoother. But as now we have been using these rules for a number of years, it has become apparent that the system is broken. I mean, in my experience, one of the most involved submissions in an arbitration is the document production phase of an arbitration. Sometimes we have to draft or to respond to hundreds of document requests and spend a lot of time and money, drafting these elaborate reference schedules. And at the end of the day, we have to ask ourselves, how many times have we actually found the killer document, the one document or the two documents that enabled us to win this case? That is hardly ever the case. So, if we do a cost-benefit analysis, I don't see the point in carrying on with this very involved and costly process. Something needs to change.
Thank you, Michalis. Unless you have a quick rebuttal comment on that, Laura, I have a question for you. Or you want to say something?
Yes, I would like to comment on the last sentence of my colleague. He said that document production are basically useless because they rarely contribute much to the outcome of the dispute. And it's true that the drafters of the Prague Rule actually explained that it's very rare for the document production to bring a smoking gun to light. But even in this case, I consider that these proceedings is beneficial, because the mere fact that document production may be used induces the party holding the documents to refrain from making false statements. We've all been there, so I think that it's not a good argument to abolish document production.
Okay, and I will follow on not necessarily on this, but on the fact that the IBA rules have been recently revised and well in force since December 2020. And it's funny, obviously this comes after the Prague Rules have been enacted in 2018, and going through the different commentaries and going through the revised rules, I don't see any, let's say, comments to the Prague Rules or any reference or implied reference to it, or any, let's say, accepting any kind of criticism that's obviously some part of the arbitration community has voiced with the Prague Rules. And I was wondering if why that would be the case or not be the case, and in particular a specific question. One of the modifications in the IBA rules is that the IBA rules can be applied in whole or in part. There's a modification in that. And do you see, Laura, why not this opportunity to apply partly the IBA rules and partly the Prague Rules? Or is that totally not possible because we're talking about the dark side or the good side?
In theory, it's possible to apply only part of the Prague Rules, but I don't see the point again. For the same reason as explained, yes. In theory, it's possible. That's what the drafter said, yeah.
Okay, well, I think we've done also the debate. We went through the two positions, and our debaters have also provided their counter arguments. I think we'll now launch again the poll and see whether there's been also some persuasion from both our debaters. And we'll see if we have some time for some questions afterwards. So go ahead with the poll. A few people have already answered. Maybe we'll wait a few more seconds to see if more people participate. I think it doesn't really change now. So Rafael, you can share them. And actually, well, if I review the first poll, it was 59-41, and now we have 54-46. So there's been some shift, but there is still a majority of the audience that believes that we should restrict document production. And that ends this second debate. Thank you so much, Michalis and Laura, for your presentations, for the force of your opinions. And I think we do have a short period of time, a very short period of time for some questions, if someone has a question to share with the debaters. I do see on the chat that Claudia has shared a question. You can also share it orally. Claudia, if you want to share with us the question, or otherwise I'll go through it. I'm not sure if Claudia is hearing us, or if she's still there. No. Well, I'll go through the question if that's fine for the panelists.
She's asking you, actually. She's asking whether she can speak.
Yes, yes, you can.
Hello, thank you for ability to talk. I was just thinking, for instance, because of time, we know that documents production is very complicated thing, because we know that each country has its own legislation, and even on different matters. For instance, some companies have LLP, other GmbH, etc., etc. And therefore, we don't know what will happen next. And even the force majeure made so many things and documents that even have never existed before. Therefore, for instance, I was thinking about timing. For instance, we know that we should make some restrictions for operating more simply arbitration and even the procedures. And maybe my English is not correct, but I was thinking about timing, for instance, about the procedure. For instance, if we will restrict time for presenting documents and the procedure of having the process, maybe it will be helpful for making our processes lasting less time. And even, for instance, for the forwarding goods, for instance, for goods of FMCG, we know that it can be rotten fastly. Therefore, for solving problems, it's better to decide this case very fastly, because we know that, unfortunately, it happens that even if you won the case, the some important issue is to execute it. And it happens that even if you won the arbitral case and you come to the country to execute it, and you find out that this company has nothing, sorry. And therefore, the company that initiated arbitration procedure loses money and think why it should participate in arbitration procedure, because due to the longing procedure, they lose money, and the case that they will gain from it is questionable. Therefore, maybe timing is better for arbitration because it helps them to solve it fastly and therefore obtain their money. We all want to be right, but the main thing for me and for maybe most of clients is to gain their money back sometimes. And due to the long procedure, the person can be right, but can he or she or it obtain money back? And therefore, I was thinking about timing. If we will restrict time, not procedures, not documents, because we don't know what will happen next, what documents will be created next, because the technology develops, everything develops, but timing is...
Yes, Clavidia, sorry, I'm sorry to cut you. I think because we don't have a lot of time, and I just want to at least leave the opportunity to our panelists to answer. I understand the gist of your question is this aspect of restricting time, and I'm sure Laura or Mihalis or Nina or Stefan may want to answer to that, the question of timing in terms of document production. If you have something to say.
Okay, Mikhail, yes?
No, I was going to say that my initial reaction is that if we have strict deadlines for document production, the likely outcome is that you will have armies of associates working around the clock to submit the same number of document requests, just in a shorter time frame. So I'm not sure this will really resolve the problem.
Thank you, Mihalis. You wanted to mention something, Laura, or?
I didn't think about that, but I think he's right when it's possible. He's right that more people would just work on the same document production, and then it doesn't mean that that the scope would be less important. But anyway, in the procedural calendar, there should be strict deadlines, as you mentioned.
Okay, thank you, Laura. Unfortunately, I would like to obviously leave the floor for more of you to ask some questions or some comments or some more stories of your experiences on either summary disposition or document production. But time goes by quite quickly, and now we have the next step of this session is the breakout rooms. So I'll leave it now to both Ben and Anya and Rafael to just tell us what's going to happen next. And obviously, I'm here to thank all four debaters for this debate. It has helped me in fishing some insights for my current cases. So thanks a lot for the four debaters for the positions. So Ben and Anya and Rafael, it's back to you now.
Thank you, Tomas. Yes, and indeed, thank you to our debaters for your positions, for your excellent presentations and arguments. As just a closing remark from my side, I would say it always strikes me how passionate we can be about the scope of discovery as a theory, and then and what standards should apply. And in reality, I wonder if the lawyers will always find a way to make expansive document production requests, regardless of the standards that are applied or agreed with different tactics. So that's my personal experience. But I look forward to discussing this more with you all during the apéro. And so I'll send it over to Ben for his closing remarks as well. Thank you all so much.
Yes, thank you, Anya, sorry. So I thought the debate on summary dispositions was just great. Also, it touched in a very sophisticated way on the efficiency concerns that might prompt clients in particular to embrace this type of procedural tool, but also on whether summary dispositions can really make a practical difference. These types of tools do tend to be a double-edged sword. So I think we need to tread carefully with respect to it. But again, thank you very much to all of our debaters and to Thomas for doing such an excellent job with the moderating. And we're gonna move on now to the happy hour breakout. So without having to do anything, you'll all be randomly put into one of our breakout rooms with a few other people, and hopefully you'll meet some nice people or get to see people you already know. There'll be 2 rounds of this of 10 minutes each. So in each breakout room, you'll be there for about 10 minutes. So please do stay on. Thank you again, everyone, for participating, for listening. I think this was a great first Swiss Chalet debate after several years of hiatus, and hopefully we'll organize another one in the fall. So thank you again.